Hello, good afternoon, and welcome to all of you who is already present here to our next life sciences session. I think, if I'm not mistaken, it's the 9th life sciences session, and it may, I think, have been a couple of months since our previous one. That being said, we have a topic prepared for you, which we hope will be interesting. At least we get a lot of questions on this topic. So without further ado, life sciences session on hot topics for healthcare tendering. This one doesn't work, apparently, the stick, but I'll use. Yeah, okay. So we have 4 topics today for you. The topics are listed here on the slide. The first one is a general one, an appetizer, let's say. Do GPs, HCPs fall within the scope of public procurement laws? I will deal with this topic together with also Article 10 of the Medicinal Products Act. It's a recurring topic, so the gift that keeps on giving. And then subsequently, Caroline de Mulder, my specialized colleague actually in the field of public procurement, will deal with price revision clauses and supply contracts and with biologicals and biosimilars and how they are treated differently or comparably. Just for the sake of, let's say, organization of the session, you are invited and welcome to ask questions. If you have questions, please do. You can do so in the Q&A chat. We will deal with the questions normally at the end of the presentation because the questions will not pop up on my screen, but we will see them while we're presenting on the other screen. And so we will deal with your questions at the end. If there's something very urgent or you need to leave, please also add it in the question. The session will last normally until, or at least our presentation, until 2:15, and then we will have 10 to 15 minutes for Q&A. First topic, do GPs or HCPs, healthcare professionals, fall within the scope of public procurement laws? It's an appetizer, as I said, because it helps us to understand who is actually subject to public procurement rules. In this regard, public procurement rules deal with, first of all, legal entities. Secondly, legal entities who have a specific purpose to provide needs of public interest, which are not industrial or commercial. And thirdly, and this is of course particularly important for the life sciences field, in regard of activities that are mainly financed more than 50% or controlled by the government. That was decided in the Court of Justice decision on Oymans, and it's that also means in the as held that also direct or indirect funds from public insurance schemes, so such as reimbursement compensation that hospitals or GPs will receive from the National Institute for Health and Disability Insurance. So that's also why a lot of actors in the field will fall within the public procurement laws, particularly practically all Belgian hospitals. And then a question, it's not a question, although the title of our presentation is hot topic. It's perhaps not the hottest topic because it's not a question that we see frequently, but what about HCPs? Because it may be counterintuitive, but also HCPs, general practitioners, dentists, ophthalmologists, or other specialists may fall under the public procurement rules. When do they fall under the public procurement rules? When they are incorporated, a legal entity such as a BV, when they practice and provide you with care and under their BV, their legal entity. And secondly, if the activities are mainly financed from direct or indirect funds from public insurance schemes, as I said before. They will not fall under the public procurement rules if they are not incorporated, of course, if it's an eenmanszaak, which is something very particular also for GPs. So if they don't have a legal entity themselves, or if they are not mainly financed from direct or indirect funds from public insurance schemes. That also means, for instance, plastic surgeons and privately funded practices will not fall under the public procurement rules. Why then is the focus of these types of seminars as today always on hospitals? Well, of course, because there's, from a practical perspective, a difference in market size and market impact. GPs and other types of HCPs will have less of an impact than a hospital procuring a number of products. Legally also because the value of purchases also impacts tendering rules. What is important here is, of course, GPs and HCPs will not procure the medicines as such. It's the hospital or it's the pharmacy, but that doesn't mean that they can't procure medical devices. And as this is a life sciences session, which also covers medical devices, that can indeed be the case if they procure a medical device of a significant value. Particularly, this may become increasingly important. So what is the impact of the value for tenders not exceeding the amount of 30,000 euros? So a tender of limited value, it's possible for the HCP to order on the basis of an accepted invoice, which means they compare, let's say, 3 possible offers, can be an actual offer or a possible offer based on what you can find online. And they examine and or contact these 3 suppliers, following which they work with an invoice that is accepted. That is sufficient for these very, very limited value tenders. For tenders not exceeding the amount of 140,000 euros, or if only one supplier can be contracted due to, for instance, exclusive rights such as patent rights, or for technical reasons, it's possible to organize a negotiated procedure without prior publication, in which case, of course, the award should be published afterwards. This rule, of course, also applies to hospitals, but the value will often be increasingly higher for hospitals. If that is not the case, if these thresholds are exceeded, or if the condition of exclusive rights, technical reasons, and as a result, one supplier being capable of providing what is requested or what is purchased, in those cases, you have to comply, the hospital or the HCP, with the more stringent rules under public procurement law. So that for the first, let's say, appetizer topic, which gives me the opportunity and possibility to discuss the second topic. And I can assure you this is a hot topic in tendering. So Article 10 of the Medicinal Products Act, what is it about? It's a prohibition to promise, offer, or grant, directly or indirectly, gifts, monetary advantages, or benefits in kind. This prohibition applies within the framework of supplying, prescribing, delivering, or administering medicines or medical devices. So definitely also in the framework of hospitals, to wholesalers, intermediaries, persons qualified to describe, deliver, or administer medicines or medical devices, and institutions. So here's the hospitals also where prescribing, delivering, or administering of medicines or medical devices takes place. So you have to be careful, in other words, what you grant as a pharmaceutical company, for instance, to hospitals in terms of gifts, monetary advantages, or benefits in kinds. There are strict exceptions in respect of which this prohibition does not apply. Most of you will be aware of these exceptions, so I will not discuss them into further detail. It's the exception of limited value, is the exception of scientific events, and is the exception of clinical trial support for clinical trials. So Article 10 of the Medicinal Products Act is what we call in legal terminology the lex specialis, which means it's a law which applies particularly to these types of benefits, to these types of institutions, and people who are involved in the prescription and so forth of medicines and medical devices. It applies in addition to the general legal provisions on public procurement. So if some companies will have to apply and comply with Article 10, others with public procurement, but particularly for hospitals, in most cases, they will have to comply with both public procurement and Article 10, as a result of which this is an important topic. So as many of you may know, scientific and other assistance criteria are increasingly part also of hospital tender specifications, and they are often used as award criteria. So criteria on the basis of which they will determine which supplier to choose. In principle, these benefits are defendable if they relate to the relevant product being procured. That is, let's say, in a certain sense, also the most essential rule. They have to be related to that product to which is concerned by the, for instance, tender. And the question is then, so it has been discussed in some decisions dating back to 2017 and 2016, where there was indeed a request for benefits by, in this case, university hospitals. And the question was whether that was allowed and whether, of course, the participants were allowed to offer these types of benefits, or whether this exceeded actually the public procurement scope and what was allowed in that regard. It was accepted in both cases by both the president of the Dutch language and the president of the then also French language first instance court. It was accepted, but there was also this additional sentence in this decision which said, well, of course, if you're asking for support in regard of or in respect of research, a university hospital has, of course, a specific obligation or assignment, or its task is specifically also on research. So as a result of that, it's not extraordinary, it's not unallowed also to ask for these types of benefits. That being said, there has in the meanwhile also been a circular of the Federal Agency of Medicines and Health Products, and the federal agency, the FIA, FMPS, has discussed whether or not you can ask, as a hospital being, ask for benefits in the framework of public procurement, and whether pharmaceutical companies and or medical devices companies can offer these types of benefits, whether that is allowed or whether that is prohibited. So additional benefits, the first criterion or the first question is it linked to the public procurement? That's a bit what I said before also, this essential condition, it has to relate to the relevant product being procured. So what about additional benefits, educational materials, patient monitoring or software, support for research and support for how to use medicinal products or medical support? You have to really look into what is being requested and ensure that you can tie it to these benefits, tie it to what is being requested. The second is, of course, there is a benefit here for the contracting authorities, for the hospital, and it also means you're giving something to the contracting authority, so it can't be free of charge. That is what the federal agency explicitly stated. So it's rather stringent, but it's of course a circular of the federal agency, so it has to be taken into account. Definitely when we advise our clients, we definitely do that. The rule is from, and that's particularly stated by the federal agency, is that there needs to be a specific price, or the price or the value, let's say, for the benefits that you offer need to be included in the price that you offer or that you ask in your offer for the products to the hospital, for instance. What does that mean? If the hospital asks for specific benefits and asks you to list the price that you would ask for these benefits, so price for benefit 1, price for benefit 2, price for the products that you want to or need to supply, and then providing a total, of course, you need to specify the price for the benefit explicitly. If not explicitly asked, then I would say that's probably the majority of the cases. It's sufficient to stipulate that the total price that you ask for all these products, together with the benefits that you grant in respect of them, includes that the total price includes also the offer of the products and all these benefits. It's important to stipulate that because that's actually what's referred to in the federal agency's circular letter. Of course, that doesn't mean that this sentence can be just fictional. If you're saying it's all included in this price, but then you're asking a price which is actually entirely for 100% related to the offer of the products, without actually asking a price for these benefits, then it's a fiction, and you can, of course, in an investigation, be asked to disclose how you came to this total price. And in that regard, it's important that you ensure that all separate aspects have been budgeted, so also the benefits, and that this total price with all separate aspects finds support in internal housekeeping, so that you keep good documents to support in case of further examinations or investigations. Last point from my perspective is, of course, watch out for abnormally low tenders. If you're asking in respect of the benefits certain price, but as a result of that, you're asking an abnormally low price for your products that you're offering, you can be in breach of competition law, public procurement, and perhaps even Article 10 of the Medicinal Products Act. So I think that was it from my perspective, and I'd be happy to pass the floor, or to give the floor to Caroline. Thank you for your attention.
Thank you, Kilian, for the introduction. So I'm indeed going to take over with the next hottest topic. It's being price revision clauses in supply contracts, because of course, that's what everybody's asking. What about the price can be revised? So first, a very, let's say, depressive graph provided by the EMF on what drives inflation. And as you see, there's food, there's energy prices, there's transport, housing, water, electricity, all those drivers which lead to the inflation which we are currently confronted with. And specifically in the context of Belgium, we also have a lot of indexation of the wages. So it's no need to say that there's a lot of pressure on prices throughout the whole, let's say, economy. So how to cope with the current economic climate in the framework of public contracts? Well, there is, of course, such a thing as price revision clauses in public procurement. A price revision clause is considered as a modification of the contract under public procurement laws and is only possible if the contract documents, being the tender documents, explicitly provide for such a price revision clause. Being, if there is no such clause in the tender documents, then you're not entitled. There's a specific article of the Royal Decree of 14 January 2013, which is basically the decree which covers the standard set of rules which apply to the execution of public contracts. Well, it does foresee for works a mandatory price revision clause, but for supplies and services, sorry, excuse me, there's a mishap here. No worries, everybody's fine. But for works, it is in principle mandatory. For supplies and services, it's optional. And of course, taking into account the nature of the hospital tenders and taking into account the nature of life sciences practices and healthcare tenders, it's of course the supplies and the services which are, let's say, relevant here. So for supply and services, it's optional, being not mandatory. And what we see is that not a lot of hospitals include such price revision clauses when they supply for medicinal products or when they request, for example, services for medical devices. So what can you do when you're confronted with that? Well, basically, as I said, you should always check your tender documents for a price revision clause, and that relates to awarded contracts. So if you have, of course, your awarded contracts, it's always useful to check whether or not such a price revision clause is included, although the chances are not very, let's say, not very high that it will be the case. What is a possibility to do for ongoing tenders? Well, seeing the nature of the current climate and the volatility of the market, it might be wise to ask a question in this respect. ask for a specific price revision clause, because it's also to the benefit of the hospital itself, because otherwise all the tenders and the suppliers will include a very high risk percentage in their price, and perhaps it's more to the benefit of the hospital to only pay for the risk when it occurs. So it might be, let's say, a way to ease them into introducing a price revision clause. Also, another reason why they might want to do that is because they don't want to have incomparable offers, because if somebody is taking into account the risk of inflation and somebody else is not, then they're comparing apples with pears. But the main and the most important message is, as I said before, if no such clause is included, the prices remain fixed for the duration of the tender. But as you noticed, there's a but, a big but, or maybe not such a big, you will see later. There's also such a thing as hardship in public procurement. Article 38/9 of the Royal Decree provides for a hardship clause, which allows the supplier to request for a financial compensation if, and now you're going to see a lot of cumulative conditions which all have to be fulfilled in order to file for such a financial compensation. And the first one is, that's of course the most important one, it has to be unforeseeable. It had to be, when did it have to be unforeseeable? At the time of tender submission. Of course, if you submitted your offer in 2019, then the COVID crisis and the energy crisis which followed were certainly not foreseeable. If you, of course, submitted a tender offer in, let's say, October 2022, then those crises might have been foreseeable. So it might not be, let's say, unforeseeable. So that's always, I think, important to take into account. It has to be unforeseeable at the time when you submit the tender. And then secondly, the circumstance invoked could not have been avoided and the consequences of it could not have been remedied, even though the good supplier had done everything necessary to avoid such. For example, the mandatory indexation and the spillover of the index, that's not something which you can avoid. Energy prices rising, that's also not something which you can reasonably avoid. So I think the second one is less difficult to fulfill than the first one. And then the third one, and that's where it usually goes wrong, but due to the current inflation rates, perhaps not, no longer, it has to be a major adverse consequence. And what is a major adverse consequence for supplies? It should be at least 15% of the initial contract value. And this is a very high threshold, especially for supplies and services. For works, it's lower. It's 2.5%, so that's different ballgame. But for supply contracts, 15% of the initial contract value, that seems a lot. But with the current inflation rates, who knows where we will end up. So that might also be a threshold which might be reached in the future. And then the fourth, and I would say from my legal perspective, always the most important one, is the notification. You should have notified within 30 calendar days after you became aware of the circumstance which have led to the increase in the initial contract value. You should notify the hospital. And if you do not do it within those 30 calendar days and you do not notify them of the possible impact on cost and time, unfortunately, your request will be time barred afterwards. So that's always a very important one. Whenever you see a trend arriving in the market, such as inflation, or whenever you've been made aware in the newspapers of another indexation round, etc., or the rise of energy prices, you should always notify the contracting authority, the hospital, timely, being within 30 calendar days from the moment from which you've been notified thereof, because otherwise you will not be able to claim. So although hardship might be a good backup plan, in practice, it's not always the case, because effectively the current climate, the current economic climate, is not something which, let's say, occurred yesterday. It's something which has been built up throughout the past years and months. So it's very difficult to, let's say, timely notify the hospital thereof. So, but let's say it has been used, but I don't know whether it has been used very successfully. It will depend on the notifications that have been sent in this respect. So then we go to the last hot topic, and I think the biggest one. And it's, of course, it's a recurring theme, and we've been giving a lot of updates in this respect because it's ever evolving, and it's about the biologicals and the biosimilars. Same but different, that's always the question. But now there has been the Belgian legislator who has intervened. So what is it about? I'm going to give a short recap. In 2016, the Minister of Health, which was Marie de Blok at the time, wanted to increase the use of biosimilars via public procurement. And it was launched as the Action Plan Biosimilars. There were covenants and circular letters issued at the time. But let's face it, after a while, it seemed that the circular letters and the covenant had little success. So in 2019, they wanted to create a task force of biosimilars, which was created within INAMI. And the outcome thereof led to a note, which the details are mentioned in our presentation. And the aim of the note was, or at least the conclusions of the task force for biosimilars, were that there had to be specific measures to streamline the tender process in order to facilitate inclusive biosimilar policy. And they suggested, the task force suggested, to give broader power to the king to draft a royal decree which would govern the implementation of these specific measures in order to promote the use of biosimilars. We shift to November 2021. A draft bill was introduced which contained various urgent provisions relating to health. And in this draft bill, which was later on adopted on the 18th of May 2022 and published on the 30th May of 2022, there was a specific provision which relates to, let's say, the tendering of certain groups of underused medicines and public procurement. And this is the, let's say, the hot topic of today. So what's the fuss about? And it's specifically, when we go into the technicalities of the Act of 18 May 2022, it's about Article 74, which introduces a new Article 71 bis in the Act of 14 July 1994 on compulsory insurance for healthcare and benefits, or the Healthcare and Benefits Act, as the ZIFWIT, as known to all of you. And what is the purpose thereof? And the aim is described in a rather broad way, but we all know better, you all know better, the topic is biosimilars versus biologicals. So although it's aimed to have a wide reach, and it's also written that way, the focus is clear on the biologicals versus biosimilars discussion. And the aim and the purpose of this new Article 70 bis is to correct the lack of competition and the suboptimal use of public procurement legislation in the hospital sector. And they want to reduce barriers and thresholds in tender documents and what they call the use of irresponsible and to some extent unnecessary award criteria, which of course restrict competition. And what can the king do in accordance with this new Article 71 bis? Well, the new article grants the king the possibility for a specific group of medicinal products or medical devices, because it does not only relate to medicinal products, but it also applies to medical devices. But this specific group should be reimbursable and underutilized. And for this specific group, the king can impose conditions and time limits within which public hospitals must award a public contract. He can also impose conditions which the tender documents must meet, such as the content, and this is really specific, the content of selection or award criteria, or even can come up with a set of technical requirements or obligations with respect to the division into separate lots. Also key is that he can impose a maximum duration of a contract. Although it's not such a big novelty, because in general, in public procurement laws, framework agreements can, the standard, let's say, maximum duration is 4 years. So we already know that from public procurement laws, so we don't know specifically what kind of additional value this will have. We'll still have to see, but that's also in there. And of course, as always, the king can also draft exceptions and exemptions to the above rules. And also, and this is also quite important one, he can introduce a mandatory inclusion for an early termination clause in the event of change to the reimbursement basis of the medicinal product or the medical device concerned. But that's also more a technicality, but the royal decree, if it would be drafted by the king, would also apply to hospitals that would acquire medicinal products through a central purchasing body, or even when they would occasionally jointly procure medicinal products or medical devices. What's also in Article 71 bis is that the hospitals must provide all information in this respect to NISD upon first request. So this is also unseen, let's say, in public procurement, that a contracting entity should provide the government with, let's say, all information how they comply with public procurement laws, and in this case specifically the royal decree to be drafted by the king. So which specific groups can be targeted by the king? Which specific categories of medicinal products? Well, it can be a variety of medicinal products, as long as it's a homogeneous group which is sufficiently and clearly identifiable, and the biggest one, that are underused due to barriers to competition. And I've summed up a list of specific groups that we can imagine. And of course, the first one is the most important one, is a specific category with a well-defined legal status, and those are the generics or the biosimilars. It can also be medicinal products at a therapeutic level. It can also be on a molecular level, or even it can be a certain class of medical device. So those specific groups can be targeted as long as they're underused. But of course, as I said, let's say that the red one is the most important one. And if you read all the preparatory works to the draft bill, and it only leads to the conclusion that those provisions are drafted specifically for the biosimilars versus biologicals discussion. But what are the concerns? Well, first of all, legal uncertainty. Because it's not that easy as it might seem, or as it is presented by the legislator, to, let's say, define the specific group and define whether or not it's underused. How will this be determined? That was also the comment of the Council of State when they reviewed the draft bill. How will those groups how will they be identified? So this will for sure create a lot of legal uncertainty with respect to scope. Secondly, are those measures indeed better for the budget? Because of course the aim when promoting the biosimilars is to, let's say, reduce the pressure on the budget, but will this be the case? For example, if you come back to the early termination, if you would include an early termination in your framework agreement, this will put a pressure on the price. A supplier will give a better price for a 4-year contract for which he knows it's not going to be terminated than for a contract which he knows that can be terminated at any given time. So will it indeed be better for the budget? That's the question to be that remains open. And then thirdly, but that's always the question when we talk about public procurement, there's always the issue of therapeutic freedom. How will the therapeutic freedom of the healthcare practitioners relate to the royal decree? And then also a major concern are the severe sanctions for the hospitals, which are included in the new act, because in case of non-compliance with the special measures imposed by the royal decrees, or non-compliance with the obligation to provide information and to cooperate with the NISD, it might impact the lump sum reimbursement of the hospital, which can be lowered with a certain percentage, up to 10%, and for a certain duration, which can be up to 12 months. So needless to say that this might have a specific and a very big impact on the hospitals. So they might be very, let's say, risk averse when drafting their tender documents. And what is to be expected from the king? Because as I said earlier, this is just the mandate. The new Article 7 bis is the mandate for the king to draft royal decrees. It's not enforceable as of yet. It requires a royal decree from the king. It's to be seen, because at this stage, no such royal decree has yet to be published. And also, it's a lot, let's say, for us public procurement practitioners, it's also a very strange, let's say, creation, this new Article 71 bis, because it will be the first time that public procurement rules will be amended for a specific sector on an ad hoc basis, and then basically for only a specific segment of products, being those who are underused. Also, to me, but that's purely from a public procurement perspective, it's definitely not clear what the additional value is of such rules, as the current regulatory framework already offers sufficient protection in order to ensure competition. So for me, and especially based on the content of the new Article 71 bis, it's still an empty box. But the question remains of whether this empty box will become Pandora's box, because there are so much uncertainties on how the king will, let's say, put his mandate into practice. What do we expect? Disputes, for sure. I mean, we expect that the royal decrees will be attacked, because the royal decree requires, as I said before, that a specific group of medicinal products or medical devices will be identified, which has to be based on it has to be done in an objective way and on the basis of data. But seeing that there is it's so contested, there will be a lot of discussions whether or not the king has clearly defined the scope and whether or not those products can be conceived as underused. So only from that perspective, it seems that the royal decrees are let's say, very easy to attack. Secondly, not only the royal decrees, which will impose additional measures, will be, let's say, prone to disputes, but also the tenders themselves. Because if the tenders do not take into account the specific measures imposed by the king, this will be, of course, subject to scrutiny from, let's say, a biosimilar, a company who has biosimilars who wants to participate in a tender. So I don't think that the new Article 70 bis is an improvement at all. I think it will only lead to more legal uncertainty and will create more hurdles for procurement in the healthcare sector. but let's say the saga continues. So maybe in the next update we will discuss the first royal decree and the consequences thereof. So yeah, let's see. And that's, I think, the presentation from our side. I think, Kilian, if there are any questions. There are questions from Kilian. Well, Kilian asked me how the royal decree can be contested. Well, it can be contested in front of the Council of State, but it has to be done, let's say, within the specific time frame from publication of the royal decree. So it has to be done within 60 days of publication if you just want to file for an annulment. If you want to file for a suspension, we will have to check whether or not those conditions will be filled on an ad hoc basis. But I think the most important one, and of course we will also follow that up for our clients because we monitor the official state, the Belgian official state gazette on a daily basis. So we will check that for you. If we become aware that such kind of royal decrees will be published, we will put out an alert. And from the date of publication, you have 60 days to attack it. As I said, I already gave some flavors on how we could do that, on the basis of which arguments we can do that. But still, as there are no royal decrees available yet, it's still to be seen. We will still have to make the evaluation at the time. But for me, taking into account the objections of the Council of State, which were already raised at when the draft bill was introduced, I think there's a lot of meat to attack such royal decrees. So I'm quite confident that we will find a way to let's say attack them. But it's 60 days. So from publication, it's 60 days. So that's like the one shot in the beginning. Afterwards, you can, of course, dispute a royal decree on a more ad hoc basis, but let's say the 60 days is key. But as I said, we will monitor it and we will issue an alert to all of our clients when such an event would occur. We'll leave the floor open for another 5 minutes for questions. Yeah, just shoot. Kilian will drop them and I will try to answer them. That's how we arranged it between us. So. And in the meanwhile, I already have the slide in front of me, but I didn't do it yet. I already want to thank you on behalf of Altius, especially on behalf of Kilian and myself for being present during this seminar. It's actually been my first doing this virtually, so I hope that I've done it well and gave enough glances into the camera. But if not, I will try to do it better next time. And of course, the slide deck will be circulated later without typos.
Mm-hmm.
Yeah, I saw two as well. So apparently all our slides were super clear as there were no additional questions. So it leaves, I can only thank you again and see you next time in the 10th. It's an anniversary edition, so perhaps then we'll be with special guests and cake, virtual cake. So see you next time. Bye.